voice, both poetic and profound, redefined the role of judiciary in promoting social justice, human rights, and constitutional morality. An unwavering commitment to progressive jurisprudence, compassionate justice, and people centric law made him a towering figure far beyond the courtroom. Let us pay tribute to Justice V.R. Krishna Iyer, a visionary whose memory we cherish with reverence on this occasion. The honorable dignitaries for the day has arrived. I invite Honorable Mr. Justice Bhushan Ramachandra Gavai, Honorable the Chief Justice of India, Honorable Mr. Justice Nitin Jamdar, Chief Justice, High Court of Kerala, Honorable Mr. Justice Devan Ramachandran, Judge, High Court of Kerala, onto the dais. Let's commence by lighting the ceremonial lamp and officially inaugurating the ceremony. I invite our distinguished guests to do the honors. I invite Advocate Fatima for the prayer song.
എങ്ങുമെങ്ങും നിറയും വെളിച്ചമേ, എൻ മനസ്സിൽ നീ ശാന്തിയാകണമേ. എങ്ങുമെങ്ങും നിറയും വെളിച്ചമേ, എൻ മനസ്സിൽ നീ ശാന്തിയാകണമേ. എൻ്റെ പാദം ഇടറാതിരി ചൊരിയണമേ. എങ്ങുമെങ്ങും വെളിച്ചമേ, എൻ മനസ്സിൽ നീ ശാന്തിയാകണമേ.
I invite Justice K. Krishna Iyer, President, Sharada Krishna Sadgama.
Dear Dr. Justice B.R. Gavai, Honorable the Chief Justice of the High Court of Kerala, Honorable Mr. Justice Devan Ramachandran, Advocate Sanan Ramakrishnan, Secretary of the SKS Foundation for Law and Justice, respected sitting and former judges of this court, respected members of the bar, esteemed guests, dear friends, ladies and gentlemen, a very good evening to all of you. It is my memorial law lecture. This gathering is not just a formal tradition, it is a moment of reflection and reverence, a tribute to one of the greatest jurists India has ever known, Justice Vaidyanathapuram Ramayar Krishna Iyer. Justice Krishna Iyer was not merely a judge of the Supreme Court. He was a moral voice, a compassionate humanist, a visionary who believed that law is not an instrument of power, but a tool for justice. He gave life to the Constitution, not just through rigorous legal reasoning, but through empathy and imagination. Whether expanding the meaning of Article 21, the right to life, or breathing life into the directive principles, he strove to ensure that justice was not a privilege for the few, but a promise to all. His judgments were not cold pronouncements. They were often lyrical, bold, and provocative, echoing with the cries of the poor, the unheard, and the forgotten. It is only appropriate, therefore, that the theme of today's lecture is the role of Justice V.R. Krishna Iyer in balancing the fundamental rights and the directive principles of state policy. We are deeply honored that this lecture is being delivered by none other than Honorable the Chief Justice of India, Dr. Justice B.R. Gavai. Justice Gavai is an embodiment of scholarship, dignity, and fairness. His rise to the highest judicial office in this country is both inspiring and reassuring, a reminder of the openness and promise of our constitutional democracy. His judgments reflect judicial clarity, compassionate balance, and a deep regard for the fundamental values and that bind us as a nation. I, on behalf of SKS Foundation for Law and Justice and all those present here, extend a very warm welcome to you, my Lord, Mr. Justice B.R. Gavai.
I invite Mrs. Satyashri Priya, member of the Board of Trustees of Sharada Krishna Sadgamaya Foundation, to present the flower bouquet to Honorable Mr. Justice B.R. Gavai.
We are equally fortunate to have with us today Honorable Mr. Justice Nitin Jamdar, the Chief Justice of the Kerala High Court, who is presiding over this function. Mr. Justice Jamdar is widely known for his calm wisdom, judicial discipline, and quiet strength of character. As a judge and he continues to uphold the legacy of integrity and thoughtfulness that Justice Krishna Iyer once exemplified in this very court. I am proud to add that the bar, which is the judge of all judges, has adjudged you as one of the best Chief Justices of this court. I, on behalf of the SKS Foundation for Law and Justice and all those,
I request Advocate George Johnson, member of the Sharada Krishna Sadgamaya Foundation for Law and Justice, to present the flower bouquet to Honorable Mr. Justice.
Have Honorable Mr. Justice Devan Ramachandran to deliver the commemoration address. Mr. Justice Devan Ramachandran is known for his eloquence, his concerns. His judgments speak directly to the lives of the people. His writing is clear, persuasive, in the spirit of Justice Krishna Iyer himself. I, on behalf of the SKS Foundation for Law and Justice and all those present here,
Introduction, CEO of the Sharada Krishna Sadgamaya Foundation, to present the flower bouquet to Honorable Mr. Justice Devan Ramachandran.
we look forward with great anticipation to hearing from all these three exceptional, as the secretary of this foundation, along with his team, the entire work of organizing this function with great dedication and commitment. I also journalists from the print and visual. I also extend very warm welcome to all those who have gathered here this evening. Our respected judges, sitting and former, judicial officers, sitting and former, senior and junior members of the bar, officers and staff of this court, law students, academics, civil society members, and fellow citizens. Your presence here today is a testament to the continuing relevance of Justice Krishna Iyer's ideals of justice, equality, and human dignity. Let us remember, Justice Krishna Iyer did not simply interpret the Constitution, he made it speak to the poor, to the prisoner, to the voiceless. Let this evening's lecture not just be an occasion to honor his memory, let it be a moment to renew our commitment to those values he lived and stood for. With these words, I once again extend a most hearty welcome to you all. Thank you.
Now, I invite Honorable Mr. Justice Nitin Jamdar, Chief Justice, High Court of Kerala, for the presidential address.
Honorable Justice B.R. Gavai, Chief Justice of India, Brother Justice Ramchandran, Justice K. Balchandran Nair, President of the Foundation, Justice K.M. Joseph, former Judge, Supreme Court, Justice Manikumar, former Chief Justice of this court, my esteemed sister and brother judges, the learned Advocate General, and the law officers of the state and Union of India, the Chief Secretary, the state of Kerala, and other senior government officers present, senior advocates, judicial officers, students, and friends. It's my great privilege to be part of this function, honoring Justice V.R. Krishna Iyer, whose contribution to Indian law is unparalleled. He was a man whose life and work helped to reshape the moral compass, full voice for the voiceless. He was a rare combination of legal intellect, he performed numerous roles in his public life, that of lawyer, legislator, minister, jurist, and a social reformer. Through each of these roles, he brought a constant commitment in abstract, but in the most humane and practical form. Born in 1915 at Palakkad, Justice Iyer entered the legal profession after his father, who was also a lawyer. From the very beginning, his legal practice reflected a deep empathy for the poor and the downtrodden. He stood beside trade unionists, political prisoners, even those who were accused of unpopular criminal cases. His brief arrest early in life only strengthened his understanding of harsh conditions faced by prisoners, and it stayed with him throughout his judicial career. He was elected to the assembly, later became minister in the first elected government in Kerala. He was entrusted with crucial portfolios: law, home, social welfare, irrigation, electricity, and prisons. He utilized them to bring about progressive reforms. Justice Krishna Iyer was instrumental in the implementation of land reforms, which gave protection to the tillers and became a model for the rest of the country. But it was as a judge that Justice Krishna Iyer left his most lasting mark. On the bench, he came to be seen as a voice of conscience. One of his lasting contributions was his expansion of Article 21, right to life and personal liberty. In the landmark Maneka Gandhi case, he played a role in broadening the scope and linking it with Article 14 and 19, thereby creating a robust foundation for civil liberties in India. He accepted a letter from a prisoner as a writ petition and used it to address prison, insisting on dignity of every individual. He had a strong stand against death penalty. He emphasized the need for compassion and belief. Justice Krishna Iyer was also deeply committed to protecting citizens from arbitrary state action. Authorities accountable for public health and environmental issues. Together with Justice Bhagwati, he was pioneer of public interest litigation and expanded the meaning of state under Article 12 of the Constitution. After his retirement as a judge, Justice Krishna Iyer continued as a social reformer, writing, speaking, challenging the state and judiciary whenever he felt his conscience demanded it. His pen was as forthright as his voice on the bench. Justice Krishna Iyer passed away in 2014, and his values he upheld are very much alive. His belief that law must not be only used to maintain order, but must advance justice and human dignity, continues to inspire generations of lawyers and judges. Justice Krishna Iyer was not only a distinguished jurist, he was a movement. And therefore, it's only fitting that today, Chief Justice Gavai, who himself is a champion of social justice, is here to share with us his thoughts on the jurisprudential philosophy of Justice Krishna Iyer. We are all eager to hear Justice Gavai, and I will not stand in the way any further. I thank the foundation for giving me this opportunity and to be part of this function. Thank you very much.
Thank you, sir. Thank you for your kind words. Now, I invite Honorable Mr. Justice Devan Ramachandran for the commemoration address.
President of today's event, Chief Justice Jamdar, our most honored guest for the day, Chief Justice Gavai, brothers and sisters judges of the court and of the district judiciary, Justice K.M. Joseph, Chief Justice Manikumar, former judges of this court, learned Advocate General, senior advocates, President of the High Court Advocates Association, Chief Secretary of the Government of Kerala, friends and family of Justice V.R. Krishna Iyer, students, members of the press, ladies and gentlemen. It's absolute honor for me to be called upon to speak about a person I have revered as my guru in the presence of a equally illustrious jurist, Chief Justice Gavai. I heard Jayashankar Nambiar say last year, absolutely daunting to speak about V.R. Justice Krishna Iyer and be given 5 or 10 minutes for that. Today I've been asked to do it in 10 minutes. Absolutely unnerving. And therefore I have compiled a small note which I thought I'll present before you. But before that, just a word on how this event came to be. I think a few days after Chief Justice Gavai took over, I had an occasion to speak to him on phone. I asked him, sir, when will you honor Kerala with your presence? He immediately said, without any thought, he said, I will come to speak in memory of Justice V.R. Krishna Iyer. It was a great elation. And in fact, he said, I will come only to speak in memory of Justice V.R. Krishna Iyer. So it is a great occasion for us, and we got our game going. One word of recognition for someone who does not want his name to be taken, Mr. Parameshwar, Senior Advocate of the Supreme Court. He assisted me in organizing this, and my association with him goes back to a long way because he was my intern in my law chambers. Now to the task that I have, and I promised to do it in about 8 minutes totally. I've described Justice V.R. Krishna Iyer as a man who walked the road less traveled. The life and times of Justice Iyer is in itself a festival that coronates the most fitting of any memory. He was the people's emperor of hearts, and often the final refuge for many who had exhausted all remedies. He was thought of as a magical panacea for all ills of the society, and the confidence and the belief in him of those who came seeking his help was absolute. I've always felt that Justice Iyer was aware of this, and that at least at times he was overwhelmed by such tremendous expectations. He lives on in the hearts of the multitudes of men and women who he touched with his kindness and empathy. He is undoubtedly the tallest jurist who walked this part of the world, and no amount of hyperbole would justify his extraordinary and prodigious contributions to every facet of human life and endeavor. Born in 1914 to an equally illustrious father and a tall lawyer himself, Sri V.V. Rama Iyer, in a small hamlet in Palakkad, Justice Iyer's full name, as Justice Balakrishna Iyer just now mentioned, is Vaidyanathapuram Rama Iyer Krishna Iyer. He completed his legal studies from Madras and began his commendable legal practice in the year 1938, joining his father's chambers. Driven by idealism and socialistic dreams, he began to engage himself in farmer struggles. And as he himself wrote years later, he said, gently, I became a public figure of sorts without party affiliation. In 1948, Justice Iyer was wrongly accused of conniving with certain alleged vociferous elements and arrested. History shows that the government of Madras could not justify his arrest and that he was exonerated, but only after having to spend about a month in jail. As is sometimes said, every event in life has some purpose, ordained by destiny behind it. As George Gavai Jr. observed, Justice Iyer's first-hand experience of jail conditions and inhuman treatment of prisoners began his lifetime passion for prison reforms. Justice Iyer was thereafter elected to the Madras Legislative Assembly as an independent supported by the Communist Party. after the reorganization of the states, he was elected to the Kerala State Assembly government in India. Justice Iyer was entrusted with major portfolios like inland navigation, power, prisons, social welfare, agriculture, to name a few, which stand testimony to the trust that the then Chief Minister, Sri E.M.S. Namboodiripad, had on him as an intellectual and as a humanist. In 1950, and between that year and 1968, Justice Iyer flirted with electoral politics even as he resumed his practice at the bar. In the year 1966, my father joined him as a junior in his chambers and later recounted that how busy Justice Iyer was as a lawyer in great demand, both by the elite and the common alike. Justice Iyer's political leanings, fortunately, never disqualified him from being considered for appointment as a judge of this court, and he was sworn as one on the 12th of July, 1968. Justice Iyer's progressive vision and pragmatic capabilities were fittingly recognized when he was appointed as a member of the Law Commission in September 1971, and thereafter as a judge of the Honorable Supreme Court on the 17th of July, 1973. During his legendary stint in the Supreme Court till November 1980, Justice Iyer democratized judicial remedies and gave parturition to the concepts of public interest litigation and epistolary jurisdiction. He imparted a literary touch to his judgments, ignoring the traditional pattern, many of them pure poetry in action, as was also mentioned by Justice Krishna Iyer a while ago. He exemplified devotion to human rights, using international covenants and weaving them into the Indian jurisprudence by hermeneutic humanism, as he himself would have said. His vision was recognized the world over, and Lord Leslie George Scarman, the great English judge, wrote to Justice Iyer that he was moved by his passionate judgments in Ediga Annamma versus State of Andhra Pradesh and Rajendra Prasad versus Uttar Pradesh. In a private conversation, Justice Iyer, many years later, told me that these two judgments, where he set aside death sentences, gave his soul great solace. I had once asked Justice Iyer what his guiding principles in his role as a judge were. In his inimitable style, he said it were four and described them thus. The first lesson, he said, fundamental to life and law, is humility without hubris and humanist hearing without high bench attitude, all H. The second, which he said touched his judicial heart, was the compassionate treasury of the preamble to his exordium, we the people of India. The third was to hear either side fairly, since courage and independence, even the devil its due. And finally, Justice Iyer told me that his life has taught him that perfect justice is a mirage, that in pursuit of this illusion, we ought not to jeopardize that justice which is within our grasp. Justice Iyer's zeal and as immutable, sacrosanct, sublime, see his judgment, these are the words he has used, have made him and Justice Iyer's life and achievements to these so much that I'm not sure if I've really done justice, but I am given only 10 minutes. I believe that I am within that 10 minutes, so I'll just take one more minute to tell you a coincidence which perhaps is of absolute relevance to this occasion. Justice Iyer retired on the 14th of November 1980. And 23 years later, fitting moment for us, and we stand, sir, in your gratitude, and we are...
Thank you for that insightful address. Honorable Mr. Justice Bhushan Ramakrishna Gavai of India, a remarkable legal journey which commenced in 1985 with distinguished practice at the Bombay High Court, where his lordship served as government pleader and Bombay High Court in 2003 and Judge Supreme Court of India in 2019. His lordships made him In over 2 illustrious decades on the bench, Milords has authored more than represented India at forums in USA, UK, and Kenya, and has delivered lectures at Columbia and Harvard universities. It's a profound privilege to welcome Honorable the Chief Justice of India, Honorable Mr. Justice Bhushan Ramkrishna Gavai, for the 11th Memorial Law Lecture on the topic, Role of Justice V.R. Krishna Iyer in Balancing the Fundamental Rights and
The Honorable Chief Justice of my dear friend, Justice Nitin Jamdar, Justice Devan Ramchandran, the Judge of the High Court of Kerala, Justice K. Balakrishna Iyer, President of the Sarda Krishna Satyagamaya Foundation for Law and Justice, Sri Sadanda Ramakrishna, the Secretary of the Trust, all the other esteemed judges of the Kerala High Court, the former judges, esteemed colleague in the Supreme Court and with whom I had an opportunity to share the bench, Justice Joseph, former Chief Justice of Kerala High Court, the learned Advocate General for the state of Kerala, the learned Deputy Solicitor General, the learned Chief Secretary, the President of the Bar Association, esteemed members of the Bar, the judicial officers present in large number, the distinguished guests and the dear students who are sitting in the balcony. About a year back, there was a strong livelihood that I will, on 14th of May 2024, around the highest judicial office, and a young boy from Kerala has been assisting us in so many public interest litigations. And one day he said, "Sir, after you add on the office of Chief Justice of India, you will have to come to Kochi to deliver a lecture in the memory of Justice Krishna Iyer." It was a boon in disguise for me to get an opportunity to speak in honor of a person to whom I have worshipped. And therefore, when Parameshwar gave me an offer, I had no option but to reject it, but to accept it. And then after I assumed the office, I myself rang Parameshwar that we had decided that I will speak in memory of Justice Krishna Iyer at Cochin, and then he got in touch with Devan. Devan rang me, and that's how I'm here to pay my tribute to the person whose journey has inspired many of us, including me. It's both a privilege and a solemn honor to stand before you today for the 11th Justice V.R. Krishna Iyer Memorial Law Lecture. An occasion that is not merely a remembrance, but a celebration of one of India's most transformative judicial minds. When we think of Justice Krishna Iyer, we remember him not as a judge, but as one of the few jurists who revolutionized the jurisprudence of the country. As a young student of law in 1981, I had the distinct privilege of meeting Justice Krishna Iyer in Nagpur. My father was then the chairman of Dr. Babasaheb Ambedkar Smarak Samiti at Nagpur, had invited Justice Krishna Iyer to speak at a Diksha Bhumi where Dr. Ambedkar embraced Buddhism along with millions of his followers on the silver jubilee of Dr. Ambedkar embracing the Buddhism. And it was really an opportunity for me which I will never forget in my life. Justice Krishna Iyer, known for his remarkable jurisprudence and unwavering commitment to the marginalized, was deeply connected to the cause of the people. His presence at such a symbolic event exemplified his lifelong dedication to the values of social justice, human rights, and the empowerment of the marginalized. It was a living, breathing force that resonated with the struggles of the common man. His approach to law, a deep sense of compassion, and a commitment to social movements during my practice in support of my arguments. After I took oath as a judge, November 2003, which Devan has just now shared that incidentally, and I'm still doing that. I will not refer to my more judgments because today I'm here to speak about Justice Krishna Iyer's. As a judge of Bombay High Court in 2017, involving the rights of street vendors under the Street Vendors Protection of Livelihood and Regulation of Street Vending Act 2014. The petitioners inclusion of Greater Mumbai and the state government. The core grievance of the petitioners before us was that the town vending committees, which are bodies envisaged as central to the Act's framework, were either not constituted or were functioning without the representatives of the vendors, which was mandatorily required under the statute. Petitioners had challenged the legitimacy of the schemes and actions undertaken by municipal authorities in the absence of properly formed town vending committees. In our judgment, we held that the 2014 Act was enacted with a clear intention to protect livelihood rights of street vendors, a recognition flowing from Article 21 of the Constitution. We emphasize that the law could not be selectively implemented. The constitution of proper town vending committees with at least 40% representation from the vendors themselves was not a formality but a statutory mandate. We also clarified that while the rights of vendors are constitutionally recognized, they are not absolute. The interests of pedestrians, vehicular traffic, and general public safety must also be balanced. In doing so, I strongly relied on, let me quote from the judgment, and I quote, Justice Krishna Iyer observed legislatively crystallized politico-economics. It has been further emphasized that, therefore, an attempt has to be made to widen and deepen where legislation is found to be colorable and malified. Judges can very well declare the law to be unconstitutional. However, His Lordship further gives a word of caution that the court must be circumspect not to rush in where serious reflections will make them fear to trade, not to resort to adroit circumvention because of economic allergy to particular legislative policy, unquote. As a judge of the Supreme Court in the last year, I referred to several decisions. Recently, in the last year, in a constitution bench of 7 judges, in the case of State of Bihar versus Devinder Singh, the Supreme Court permitted subclassification of scheduled castes for the purpose of reservation. In this judgment, I referred to Justice Krishna Iyer's words in State of Kerala versus N.M. Thomas, where he had stated, and I quote, every step needed to achieve an equal partnership for the scheduled caste alone amounts to social justice. He observed that if this is not done, the Solomon undertaking of Article 14 to 16 read with Articles 46 and 335, may be reduced to a teasing illusion or promise of unreality. He observed that the law must come to terms with life and must be able to recognize the genuine differences and disparities that exist in human nature. I will mention the relevance of N.M. Thomas' judgment after a few minutes. Justice Krishna Iyer was a philosopher on the bench, a poet in jurisprudence, and a visionary in public life. His judgments were more than legal pronouncements. They were moral compasses infused with compassion, equity, and deep constitutional insight. He saw the Constitution not as a static legal document, but as a dynamic instrument of social transformation. In doing so, he brought a unique blend of legal expertise, social awareness, and moral commitment to his rulings, making him a key figure in the evolution of Indian legal thought. Overall, his influence is not only recorded in law reports, but resonates the heartbeat of our constitutional democracy, especially through his unwavering effort to achieve a harmonious balance between fundamental rights and directive principles of state policy. Today we delve into how Justice Iyer, with his unique vision and judicial prowess, navigated and indeed shaped this crucial balance. In today's discourse, I'll also reflect on some of his personal qualities. Justice Iyer's life trajectory, moving from activist lawyer to minister and then a judge, provides a unique lens through which to understand his judicial philosophy. Justice Krishna Iyer stood up for the poor and the underprivileged and remained a human rights champion, a crusader for social justice and the environment, and a doyen of civil liberties throughout his life. In 1967, it was that Justice M.S. Menon, Kerala's Chief Justice, asked Justice Iyer whether he would join the bench. A reluctant Justice Iyer agreed to be, in his word, rope-jacked. In an autobiographical account written in 2001, Justice Iyer reflected on the memorable events of his life as a judge. He wrote in his book that he asked himself, and I quote, "What were my guiding goals I tried to practice on and off the bench?" Unquote. He listed certain lessons. Justice Devan Ramchandran has already referred to them. The first lesson, fundamental to life and law, which he learned on the bench, was humility without hubris and humanist hearing without high bench pride. The second value, which touched his judicial heart, was the compassionate treasury of the preamble to the Constitution, particularly in its 5 opening words, "We, the people of India." As the democratic imperative which bound him, the third imperative was to hear either side fairly, since courage and independence obligated him to give even the devils his due. Whether he be in the right or the wrong, among the last things he learned was that perfect justice is a mirage, and as he wrote, in the pursuit of the illusion of perfect justice, we jeopardized the justice that is within our grasp. Being appointed as a judge of the Supreme Court of India in 1973, Justice Iyer played an important role in the era of judicial activism, public interest litigation, affirmative action, and a wide-ranging exercises of judicial review. He earned fame and recognition for his fair judgments, for his way of penning down the verdicts, and for his mastery over the English language. He was a thinker ahead of his time and wrote many landmark judgments. As we now reflect on the theme of the lecture. Let me quote Daniel Austin, who calls Part 3 and Part 4 the conscience of the Constitution. At the time when the DSPs were drafted in the Constitution, opinions on them varied from a variable dustbin of sentiments to the instruments of instructions. Views were expressed in the Constituent Assembly that the directive principles are no more than pious hopes, pious expressions, and pious superfluities, and then can be equated to resolutions made on every new year to be forgotten by end of January. That they are vague and adrift, that they are a check on the bank, payable when able. Defending the inclusion of directive principles of state policy, Dr. B.R. Ambedkar observed that enacting Part 4, the Constituent Assembly was giving certain guiding mandate to the future legislature and future executive to show in what manner they have to exercise legislative and executive functions that they will have to. That this principle should be made the basis of all executive and legislative actions that they may be taking thereafter in the matters of governance of the country. And as we say that in the initial days from 1950 to 1973, the various judicial pronouncements would show that the Supreme Court had held that whenever there was a conflict between the directive principles and the fundamental rights, the directive principles will have to give way to the fundamental rights. That the fundamental rights are subordinate, the fundamental rights are superior, and the directive principles are inferior to them. For the first time, this conflict was resolved by 13 judges bench in Keshavanand Bharati. Though Keshavanand Bharati is widely known for the doctrine of basic structure, the amending powers of the Constitution, wherein 6 judges on one hand held that the powers of the Parliament to amend the Constitution were limited, and the 6 on the other hand held that they were unlimited. It is a view by Justice Khanna, wherein he held that though the Parliament has ample power to amend the constitutions, and including taking away the fundamental rights, it does not have power to amend the basic structure. But I think that Keshavanand Bharati has also to be remembered for giving equal importance to the directive principles and the fundamental rights and resolving the conflict between them. All the judges were on the same page where they held that the fundamental rights and directive principles together and together alone are the conscience of the Constitution. They may run parallelly, but they intersect each other at certain points. And I also pride in saying that one of the authors of that judgment, another illustrious jurist from this state, Justice Matthews, while underpinning the importance of the directive principles, held that even the judges are a state within the meaning of Article 12 of the Constitution of India, and while discharging their duties, they are bound to follow the directive principles. Justice Krishna Iyer, with his distinctive blend of legal knowledge and social empathy, built on this balance. He understood that the framers of our Constitution envisioned a nation where individual liberties would thrive, yet not at the cost of collective welfare and social justice. He championed the idea that fundamental rights and directive principles are not antagonistic, but symbiotic. Two sides of the same constitutional coin, both essential for the realization of the preamble promise of social, economic, and political justice. Justice Iyer's compassionate view on the connection between the right to life and socio-economic rights first became visible in his engagement with the abolition of capital punishment. As a young lawyer, he had watched as an innocent man was nearly hanged in a crime he did never commit. Subsequent cases convinced him that the death penalty was barbarous and uncivilized. Not many on the bench shared this position. The court had only just upheld capital punishment in Jagmohan Singh versus State of UP. But understand, as undeterred as he was in Ediga Anamma versus State of Andhra Pradesh, he outlined the positive indicators against the death sentence under Indian law and commuted the death sentence of a convict to life imprisonment. This decision has been now followed in several other cases. In Rajendra Prasad versus the State of Uttar Pradesh, he restricted the scope of the death sentence under Section 302 of IPC. Even outside the court, he advocated for the abolition of the death sentence. In State of Kerala versus N.M. Thomas, Justice Krishna Iyer joined the court in changing the jurisprudence on affirmative action. Prior to N.M. Thomas, the view of the Supreme Court in earlier judgments was that an Article 16, Clause 4 of Article 16 was by way of an exception to the main clause under main clause 1 under Article 16. It was treated as an exception to the equality clause under 16(1). However, by a majority, the 7-judge bench in N.M. Thomas held that Article 16(4) is a facet of larger right under Article 16(1). Justice Krishna Iyer, in his judgment, went further to describe Article 16(4) as an emphatic statement of equal opportunity, emphasizing that it was not a mere exception but a vital part of the constitutional guarantee of equality. He viewed it as an illustration of constitutionally sanctioned classification, inserted separately due to the over-anxiety of the draftsman to make matters clear beyond doubt. In doing so, Justice Krishna Iyer helped reshape the understanding of affirmative action, affirming that such measures were an essential and constitutionally legitimate means of achieving substantial equality rather than a mere deviation from the principle of equal treatment to unequals. In 1980, in Akhil Bharatiya Shoshit Karmachari Sangh versus Union of India, in his concurring opinion, he wrote beautifully, and I quote, "In a given situation of large social categories being submerged for long, the guarantee of equality with the rest is a myth, not a reality, unless it is combined with affirmative state action for equalization geared to promotion of eventual equality. Article 16(4) is not a jarring note, but auxiliary to fair treatment and fulfillment of Article 16(1). The prescription 16(1) needs, in the living conditions of India, the concrete sanction of Article 16(4), so that those wallowing in the social quagmire are enabled to rise to levels of equality with the rest and march together with their brethren whom the history had not so harshly hamstrung. In both these cases, Justice Krishna Iyer read Article 16(4) with Article 46, a directive principle of state policy, to state that, and I quote, "Lucent intent of the Constitution framers emerges that the exploited lot of the scheduled caste in the past shall be extirpated with special care by the state. The inference is obvious that administrative participation by scheduled caste and scheduled tribe shall be promoted with special care by the state." And he held that every directive principle is fundamental in the governance of the country, and it shall be to apply that principle in making the laws. The view of N.F. Thomas was later upheld by the 9 judges bench in Indira Sahni versus Union of India, and principle. Now let us consider his seminal contribution of Article 21 in the case of Menaka versus Union of India, where he expressed personal liberty makes for the worth of human persons. With this power, narrow or a procedural right, but one has to embrace this right as a life, as a right to life with dignity, freedom, and full development of the individual. Now the Supreme Court has expanded Article 21 and applied Article 21 with directive principles of state policy, and various rights which were never dreamed to be the fundamental rights have been considered a fundamental right. Right to potable water, right to food, right to shelter, right to pollution-free environment, right to and so on. The list is endless and ever-growing. See with their own eyes the situation on the ground. The inhuman practice of the human beings carried the etc. of the other human beings, even after independence, was strongly deprecated by him. This judgment laid the foundation further established that a municipality cannot plead lack of funds to evade its statutory duty, to provide basic sanitation and abate public nuisances. In Som Prakash Rekhi versus Union of India, he expanded the definition of state for enforcing the fundamental rights and observed, I quote, "In our constitutional scheme, where the commanding heights belong to the public sector of the national economy, to grant absolution to the government companies and their ilk from Part 3 may be perilous. The court cannot connive at a process which eventually makes the fundamental rights as rare as the roses in December and ice in June." The case of Som Prakash Rekhi examined whether the Bharat Petroleum Corporation Limited, having acquired Burma Shell, qualifies as a state within the meaning of Article 12 of the Constitution, thereby allowing a writ petition under Article 32 for a former employees, a reduced pension and stoppage of terminal benefits. Justice Krishna Iyer's deep and abiding respect for life and liberty, rooted in the values enshrined in the fundamental rights and directive principles of state policy, is also reflected in his judgments on the inhuman treatment of prisoners. Drawing strength from constitutional ideas, he underscored the state's duty to secure just and human conditions in prisons. In several landmarks, the deplorable conditions of incarceration, but also offered constructive and forward-looking suggestions for prison reform, issuing directions to ensure that even those behind bars are treated with dignity and the constitutional principles. The case of Sunil Bhadra versus Delhi administration is one of the significant milestones in Indian jurisprudence, wherein the court dealt with the treatment and harassment of a death row inmate by highlighting the differences in Prisons Act 1894 and the constitutional rights. Justice Krishna Iyer in his case rightly observed, "Karuna is a component of jail justice. Basic prison decency is an aspect of criminal justice." Justice Krishna Iyer also strongly believed that under trials should not be kept in jail for long periods without trial. He is well known for breaking new grounds in the Indian judiciary by asserting what was once considered a taboo. Bail is a rule and jail is an exception. I am happy to state that in the recent past, this principle was somewhat forgotten. But I had an opportunity in the last year, 2024, to reiterate this legal principle in the cases of Prabir Purukasha, Manush Sisodia, and Kavita versus the ED. In Gudikanti Narsimho versus High Court of Andhra Pradesh, Justice Krishna Iyer opened his order with the poser, bail or jail. He outlined the 11 factors which included the period in prison already spent and the prospect of the appeal being delayed for hearing. He was in favor of granting bail, stipulating protective and curative conditions. He was definitely against imposing onerous conditions relating to security and sureties. As he ruled, and I quote, heavy bail from poor man is obviously wrong. Poverty is society's malady and sympathy, not sternness, is the judicial response, unquote. Justice Iyer was equally concerned about the historically subjugation of women. He once asserted, speaking of equality before the law, what is desiderated is not a mechanical or formal, but dynamic jurisprudence of non-discrimination, where gender is no disability and unfoldment of personality, sufferers no inhibition because of sex. In this case, the issue involved, in the case of C.V. Muthamma, the issue involved around gender discrimination within the Indian Foreign Service. C.V. Muthamma, the first woman to be appointed as an Indian Foreign Service officer, had allegedly discriminatory practices prevailed in the service, because of which she was denied the benefit of promotion. Justice Krishna Iyer's judgment resulted in the removal of discrimination against women officers, setting the balanced right. Thus, he broke through the glass ceiling with gender parity in traditional practices in public employment. Everybody is aware about his judgment in the case of Nargis Mirza versus the Air India, wherein the woman, the air hostess who had children, they had to discontinue as an air hostess after the first pregnancy. He came down heavily with the observations that if a man, after having children, can continue as a flight purser, why should a woman, merely because she has to discharge her duties in the aircraft, be deprived of such a right and such a restriction which prejudicially affects the natural instincts of a woman to be a mother, must not be permitted. By 1980, Justice Bhagwati and Justice Krishna Iyer became senior judges and took the Supreme Court in a new direction while evolving human principles. Justice Iyer, a revolutionary at heart, principally triggered this internal revolution. In the thought process of his colleagues, a movement vigorously carried forward by Justice Bhagwati and Justice Chinnappa Reddy. A new public interest jurisprudence was developed. The traditional locus standi norms were abandoned. Epilepsy jurisdiction was promoted, and a strategy for assisting the disadvantaged and the underprivileged was devised. As a result of this profound shift, the Supreme Court gained significant worldwide prominence and attention. This innovative weapon, which was initially employed by public-spirited citizens to file PILs on behalf of the sections of the society that were unable to do so on their own on account of the economic and social constraints, is still bringing about unheard of improvements in people's daily lives today. Justice Iyer rightly observed in this regard, when the history of the judiciary in India comes to be written, PIL will be glorified as the noblest ally of little Indian. In one such case of PIL, he treated a prisoner's letter posted from a jail as a writ petition, commenting, and I quote, "Is part of our constitutional tryst. If wars are too important to be left to the generals, surely defined fundamental rights as well as charters of freedom, not just to acquire and hold wealth from poverty and misery." Furthermore, his unfailing courtesy to the council, the senior and junior alike, and his spontaneous and unreserved appreciation of the assistance received endeared him to the bar. This is evident from his observations in state of Punjab versus Gurdal Singh council, and observed, counsel in the court are robbed representatives within the parameters of the adversary system, geared to the higher cause of justice, not amoral attorneys paid to ventriloquize the case of the principal. To summarize, Justice Iyer's more than 7 years tenure on the Supreme Court left a permanent, indelible mark. He frequently provided reliefs to litigants from weaker sections of society who might have been otherwise denied justice on technicalities. His influence stemmed from his unique values, unconventional approach, innovative methods, and the distinctive language and the style of his judgments, all of which continue to be studied and admired even today. Justice Iyer's jurisprudence fundamentally reshaped the relationship between the fundamental rights and the directive principles of state policy. He moved the courts beyond a more legalistic interpretation to a dynamic socio-economic revolution. He demonstrated how judicial activism, particularly through the pioneering of PIL, could be a powerful tool to bridge the gap between constitutional ideals of directive principles of state policy and the lived realities of the fundamental rights, making justice accessible and meaningful for all. His approach teaches us that constitutional interpretation requires a nuanced understanding of the aspirations of the people, the socio-economic realities, and the transformative goals embedded in our Constitution. As we reflect on the contributions of Justice V.R. Krishna Iyer, his abiding legacy inspires us to continue his empathic, proactive jurisprudence. I am really indebted to all the organizers, to Parmeshwar and to Devan Ramchandran for giving me an opportunity to come to Kochi and pay my tribute to a person who I always considered to be a guiding star for me, to be a role model, and to be a lighthouse. In my journey as a judge for the last 22 years, I attempted to follow the Justice Krishna Iyer's legacy towards commitment of socio-economic justice. I don't know how far successful I have been. I am really indebted to all of you for giving me a patient hearing, giving me this opportunity. And I would say that every time a bench prioritizes substantive justice over technicalities, every time a judgment expands the protective umbrella of fundamental rights for the vulnerable, every time the court exercises its powers to uphold human dignity and social equality, Justice Krishna Iyer's legacy is not just honored, but actually lived. Thank you very much.
Thank you, sir. Thank you for those profound words of wisdom. As a token of our respect and gratitude, I request Justice K. Ramakrishnan, Member of the Board of Trustees, Sharada Krishna Sadgamaya Foundation for Law and Justice, to present a memento to Honorable Mr. Justice Bhushan Ramakrishna Gavai, Honorable the Chief Justice of India. I invite Advocate Yashwant Shenoy, President of the Kerala High Court Advocate Association, to present a memento to Honorable Mr. Justice Nitin Jamdar as a token of our heartfelt appreciation. I invite Senior Advocate Lakshmi Narayanan, Member of the Board of Trustees, Sharada Krishna Sadgamaya Foundation for Law and Justice, to present a memento to Honorable Mr. Justice Devan Ramachandran as a token of our heartfelt appreciation. I invite Advocate Sanand Ramakrishnan, Secretary, Sharada Krishna Sadgamaya Foundation for Law and Justice, to propose the vote of thanks.
Distinguished guests on and off the days, ladies and gentlemen, Board of Trustees and members of the Foundation offer their deepest gratitude to Honorable Chief Justice of India, Honorable Mr. Justice Bhushan Ramakrishna Gavai, for delivering the 11th V.R. Krishna Iyer Memorial Lecture on a topic of enduring relevance chosen by His Lordships himself. Justice Gavai's address today was truly a reflection of values he has consistently upheld: justice, inclusion, and equality. Indeed, it is truly fitting that a judge who has consistently spoken for justice beyond mere formalism and who has fearlessly addressed the pressing concerns of our times, including in landmark pronouncements on reservation, secularism, and social justice, should deliver a lecture that revisits the delicate balance between fundamental rights and directive principles of state policy. Sir, your presence today and your articulation of justice beyond formalism will be remembered and cherished not just by the legal fraternity, but by the people of Kerala also. We are deeply honored and grateful to you, sir, for taking time out of your busy schedule in order to deliver the lecture. Thank you very much, sir. We express our heartfelt thanks to Honorable Mr. Justice Nitin Jamdar, Chief Justice of the High Court of Kerala, for his esteemed presence and for presiding over the function. Justice Jamdar's unwavering support and cooperation have been vital to the conduct of this event. A jurist of integrity and quiet strength, his eye for detail and clarity in administration have added immense value to the judicial ethos of this institution. Sir, your dignified presence has greatly enriched this occasion, and we remain grateful for your continued support and guidance. Thank you, sir. Honorable Justice Devan Ramachandran's address today was truly commemorative of Justice Iyer. With his natural flair and eloquence, Justice Devan Ramachandran's words illuminated Justice Iyer's towering and remarkable persona, full of compassion and concern for the voiceless, and fearless when it came to championing their rights. Thank you, sir, for sharing memories distilled by decades of close interaction with Justice V.R. Krishna Iyer's life, first through your father, late Barrister MP Ramachandran Nair, and then of your own accord. Thank you, sir. I thank the President, Justice K. Balakrishnan Nair, for his insightful and warm welcome address, whereby he set the context for this important memorial lecture with his profound thoughts and genuine warmth. The Foundation also expresses its special gratitude to Honorable Mr. Justice Devan Ramachandran and Sri Parameshwar, Senior Advocate, for being instrumental in felicitating the gracious presence of Justice Gavai for this year's memorial lecture. That too for the first time as CJI for a function in Kerala. Thank you. A special word of thanks and our sincere gratitude is due to the Honorable Registrar General of the High Court, Sri G. Gopakumar, Registrar Administration, Sri Pradeep Kumar, Public Relations Officer, Srimati Kaushalya Ramachandran, Protocol Officer, Sri Ashok, DYSP Security, Sri Santosh Kumar, and Sri Robin, IT Cell in Charge, for their wholehearted cooperation, without which this function could not have taken place smoothly. I also thank the members of the Board of Trustees, particularly its Chief Patron, Justice C.V. Ramakrishnan, Vice Presidents, Sri P.B. Sahasranaman, and Sri V.V. Siddharthan, Senior Advocate, members of the Board of Trustees, Sri Justice K. Ramakrishnan, Sri R. Lakshmi Narayan, Sri P.S. Anthony, Srimati Satyashri Priya, Srimati Girija Gopal, and Sri Nikhil Shankar, and Srimati Chandrika Aravindakshan. Your wholehearted efforts have been instrumental in the organization of today's function. Behind every edition of this memorial lecture that we hold year after year, there works silently our small team of young volunteers who work tirelessly behind the scenes, away from the spotlight, to make the program a success year after year. The Foundation expresses its sincere gratitude to Advocates Krishna Govind, who compared this event, Tasmi Taj, Anjana Kannat, Adira Menon, Fatima, Thomas Martin, Gregory, Advocate Raman, as well as for their selfless and dedicated efforts in ensuring the success of today's program. With utmost humility, we sincerely and warmly thank all esteemed members of the legal fraternity, current and former judges of this court, judicial officers of the district, including the Principal District Judge, the President and office bearers of the Kerala High Court Advocates Association, senior advocates, retired judicial officers, officers and staff of this court, friends from the media, our media partner Bar and Bench, which is live streaming this event today, all law faculty members, academicians, educators, students, and the college principals of Government Law College Ernakulam, Nuals, Sri Narayana Law College Putota, and Bharat Mata Law College for their active support and presence here today. Thank you all.
As we come to the end of the ceremony, kindly rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे